Hey, welcome back. Welcome. I read a lot of your comments on the last episode, and it's like, I don't know if I can say this, but it's like you guys were trying to feed me, I don't know if I can be allowed to say that, but it's like you were trying to feed me. I got the feeling that you guys wanted more transcripts from the family law hearing, and I got my ducks in a row, so let's get this party started.
I'm just tired of it happening. I mean, it was midnight. Child's trying to sleep and just...
Right.
Honestly, I don't always believe her when she said these things were going on, and...
She called you?
Yeah.
Okay.
Yeah, and apparently she went back inside and slept well. Was in a fine mood the next day. I guess didn't really remember calling me, so I don't know if it was just...
brought up again?
If it was just she wanted to come over to... I don't know, she keeps on trying to come over to, hang out or something like that, or... She'll come over to spend time with Lucas rather than actually just having him over here like she's supposed to, but she wants to come over there and play with him. And so,
Make sure you check out our previous episode so you can keep up with the conversation. Okay, picking up from where we left off, Sarah was all over the place and throwing out a bunch of word salad. So the judge keeps reeling her back in. So now the Judge Jackson is telling her, once again, I'm going to tell you what we're here for. The petitioner has the burden of proof, and it is up to you to tell why you are protesting. The prosecution is going to present evidence and witnesses, and you can do the same. And I'm warning you that we are not going past 5 o'clock, and it is 3:15 right now. The more you ask questions that are not on the subject, the parenting plan, the alimony, and the attorney's fees, the longer you take away from your chance to present evidence for the case. Move on. Next question.
Next question, ma'am.
Sarah takes a deep breath and she says, "Yes, Your Honor. In regards to attorney's fees, Brian?" "Yes." "Is having an attorney a choice?" And Brian says, "Yes." "Okay. In regards to commissary, was putting commissary on my books voluntary?" Oh, this is good. So Brian says, "They were partial payments as we discussed when you were first incarcerated." There's an awkward silence, and then Sarah says, "Under pre-trial memorandum, they are listed as voluntary," as if Brian just voluntarily wanted to give her $600 monthly for delicious delights and jumping Java. Motivation in a cup. So there's another awkward silence, and Brian's attorney steps in and says, "Objection." And before he's able to finish, Sarah says, "Have I asked you about a guardian ad litem?" A guardian ad litem. And mind you, Sarah's speaking very matter of fact and loud. She's actually yelling into the court. So Brian's attorney steps in and says, "Objection, relevance." And Judge Jackson says, "I'm going to need you to repeat the question. How many times have I asked you about a guardian ad litem?" And Judge Jackson agrees and says, "I'm going to sustain the objection. Ma'am, move on to something that is relevant to the topics." "Okay, Your Honor. I'm trying my best." So this is where Sarah switches gears. "How many times have you drank in front of our son?" Objection, relevance, Brian's attorney says. And Judge Jackson says, "Okay, you want to know how many times, or has he taken a drink in front of our son?" And she says, "You want to know if he's taken a drink in front of your son?" And she kind of sighs a little and says, "I'm going to overrule the objection and allow the question." So Sarah again asks, "Have you ever had a drink in front of our minor child?" And Brian says, Yes, I've had a drink in front of our child. Oh, I just rewound and heard this part also. Sarah said the reason she was asking, yes, I'm asking because he blames and ridicules me for drinking and blames that for my incarceration. So I want to know if he's taking a drink in front of our child. Sarah skips right over that, like she maybe thought that she got something, like she got one, but it really didn't make any sense. So she moves on and says, did you have a conversation with our child the other day about the application and the visitation? And did you come to the conclusion that the distance was not 1 hour and 20 minutes away? That it is in fact 50 minutes away? 50? Like the 20 minutes makes a difference. Brian says, no, I think it's farther than that when I looked it up on Google Maps. Sarah just skips from that and she takes a deep sigh and says, well, Your Honor, I don't know what else I'm supposed to do. And this is verbatim. So I guess I'll end whatever part it is that I'm supposed to be doing right now. And she sounds like she's shuffling paper. Judge Jackson says, okay, is there any redirect? And Brian's attorney says no. So she says, we're going to take a break. And we also had some laptop technical issues. Judge Jackson went on to say her laptop was about to die. And she sent her assistant to run up 3 floors on the elevator to get her laptop, and if it died, that she would be taking notes, but she was like in the red, like Sarah when she's in the negative. So she was waiting for her laptop to get charged, and they took a break, and the assistant made it back just in time. So we're back from break, and we've gotten our ducks in a row. So we are back from break. The judge has gotten her ducks in a row. Everybody's done dancing with the dogs, and Brian's attorney is ready to cross-examine Sarah. So he wants to start with the financial affidavit. And he asks Sarah, do you have the financial affidavit? I'd like to go over it with you. And she, no. And then she says yes. And he says, well, okay, go ahead and look at the exhibit because I need to go over it with you. And she shuffles through some papers and she says, okay, I have it. And he's, just confirming that she's on the right page and they're ready to go. Judge Jackson says, Miss Boone, do you have any objections to your financial affidavit being entered into the exhibit? No, Your Honor. So Brian's attorney starts and says, okay, ma'am, I want to start off on your financial affidavit and I want to laser focus on the expenses section, okay? Sarah makes some sort of noise and he says, okay, so I want you on your document. It's page 6. On my exhibit for the court, it's page 46. And there's just like dead air. And he says, Miss Boone, are you there? And she says, I'm there. I have it. So he says, you have listed here on the financial portion your expenses. You have a list here of what your proposed expenses are. And my question to you is today, have those expenses increased or decreased since your incarceration in February of 2020? Sarah feigns ignorance and she says, have they increased or decreased? And he says, you haven't actually incurred these expenses that you have listed here since your incarceration to date, right? Is that correct? I asked you the question about these expenses and you said that you haven't incurred them since you were incarcerated. So I asked a follow-up question. Have you incurred these expenses since your incarceration in Orange County Jail since February 2020? What do you mean by incurred, please? Yeah, okay. Have you had to pay them? Have I had to pay for food? Yes, I have. Okay. My first question to you though was, and you've answered it in a different way, so I'll ask you again. He's stuttering all over the place. I think he's excited that Sarah's just already admitted that she doesn't even have a reason for the expenses. My question to you is, has that number went dramatically up or down since your incarceration in 2020? I don't know as far as my needs in incarceration from 5 years ago in Orange County, but I know, and she's speaking just like this, but I know this is just an estimation because the prices, they fluctuate. So as of right now, it's about the same. It's like Sarah knows he's fishing for something and she's trying to be very careful while answering. Okay, the facility that you are incarcerated in, does it provide meals? It does. Okay, does it provide breakfast, lunch, and dinner for free? Yes. Does it provide any other meal times, snack times or anything like that? No. Okay, does it provide you things to drink for free? Yes. Water, yes. Okay, so when you indicate here that you have a financial need of $275 a month for food, what do you mean? What is that for? That is for my low blood sugar, which the petitioner is aware. I need snacks for my low blood sugar. So yes, I need to maintain my blood sugar. My grandfather died of diabetes. He goes on to ask Sarah if the facility provides hygiene products, and she says, well, they provide a small bottle of what's supposed to be lotion, soap, and shampoo, like a 3-in-1, shampoo, soap, and body wash all in one. And he said, well, that's considered hygiene, right? And she says, yes. And then Sarah goes over into some other territory and she mentions how she has a friend. That's why she has a friend that contributes to help her because former husband isn't financially providing. And his attorney hones in on that. Brian's attorney says, explain to me these contributions. And Sarah starts to sing. I have a friend that deposits money occasionally into my account whenever she has an extra finance to contribute. So if I understand you correctly, this financial request on this document is not for food, breakfast, lunch, and dinner. It's for snacks that you believe you need to maintain your blood sugar. Is that appropriate? Yes, and snacks and the meals that are not easy to digest. Yes, because the meals are not easily able to digest. And then she's quiet and says, primarily for medical reasons. Okay. And then you have another expense of $100 for gifts for holidays. Yes. Okay. Is this for gifts for yourself or for your son? Yes, they are gifts for my son. It's under child expenses. Okay. And this $100, are you asking that Mr. Boone pays you this to purchase gifts for your son because you are incarcerated and unable to afford them yourself? Okay, and I've rewinded a couple times and I can't tell if Sarah says, once he be paying or would he be paying the alimony and arrears. Yes, I would like that deducted from the amount because I can't afford to purchase the gifts myself because I don't have an income on a regular basis. And his attorney says, okay, so you want your husband to pay you alimony to purchase your son gifts. And Sarah interjects, he's my former husband. And he says, yes, you want your ex-husband to continue to pay you $100 monthly for gifts to purchase for your son on your behalf because you're incarcerated and can't afford to do it yourself? My alimony payments can be made for and spent on whatever I choose to do so. So yes, I would like to include my son in my alimony payments and purchase him gifts on holidays and just because. Yes. Okay. And you think it's fair for Mr. Boone to give you money to purchase gifts for your son because you're incarcerated and have committed a crime? It sounds like he was going to say, and have put your boyfriend in a suitcase, possibly beat him and threw him down the stairs. So he continues, you think that's fair? I think, well, it's court ordered, and I think it's not fair that I could have been paid and I did not get paid. He takes a deep breath and says, okay, you also have here a $200 charge for communications. Is that for the telephone calls we've been talking about here today? That's for all of the communication possibilities that the petitioner hasn't taken advantage of in the past, futuristically. Okay, this is a mouthful and the delusion is real. That is for not just calls, it's video visits, video calls, videograms, even digital cards. There is a multitudinous amount of technology waiting to be utilized by the petitioner. If decided to, and Brian's attorney says, okay, every effort, and she interjects, it's not just video visits. Okay, every expense that occurs. It's not just video visits. Oh, okay. Did you want to finish your point? Well, I just wanted to say it's in my exhibit that the multitudinous amounts of technology available. Okay. I want to be clear though, Miss Boone. Every expense related to the communication and these calls have been paid for by my client. Is that correct? It's my only form and ability of communicate. Ma'am, answer the question. Has your communication with the child been paid for by Mr. Boone since your incarceration, February 2020? Yes. Okay. Next question.
Next question, ma'am.
Does the prison provide you with clothing? Yes. The prison provides uniforms. And then you have $15 here for medical and dental. Does the prison offer you any medical services? You will get a lien on your account. For sick calls, you have to pay for that. For dental, you have to pay for that. Regardless if you have medical insurance or not, you still have a lien placed against your account. Okay, and you are estimating that that is $15 a month on your financial affidavit. Is that correct? Yes. Okay, and then you have here under other hygiene and writing products. Does the prison not provide you with hygiene products? This is when he's asking about the hygiene. Does the prison provide you with basic hygiene items? No. The prison provides I think 1.5 ounce bottle of a 3-in-1 shampoo and body wash, a toothbrush and toothpaste. Those would be considered hygiene items, correct? Yes. Okay. Other than contributions from third parties and money you've received from Mr. Boone, have you had to pay money out of your own pocket for any of your day-to-day expenses while you have been incarcerated? Sir, I have no money. I'm sorry, I didn't understand your answer. What did you say? Sir, I have no money. So the answer would be no, correct? Sir, I have no money or no way of... Yes, correct. Sidebar, Brian and his team are coming in strong. That's a good point. Sarah's being so demanding, yet she's not coming out of the pocket for anything. So Miss Jackson steps in. Miss Boone, I'm going to give you some time to respond to the financial affidavit, but right now I'm going to ask, is there anything else you'd like to ask or any other witnesses? No, Your Honor. I would just like to reserve some time for closing arguments. Okay, any additional evidence? No, Your Honor. I'll just some demonstrative aid that I'll be requesting in closing. So Ms. Jackson goes on to explain to Sarah that she is handing it over to her now to present any exhibits or evidence that she wants to present before closing. And this is where I was telling you guys on the live, where Sarah started to list about 100 different case law, and it was all mixed up and scrambled. The numbers didn't match the cases, and the judge kept saying, like, for instance, she would say 57327 Brown versus Brown, and she's like, no, that's Lopez versus Lopez, and give it to me again. Sarah would repeat it, and she says, no, that's Lopez versus Lopez. It has nothing to do with what you're talking about. Next question, ma'am. Next question, ma'am. So that went on for about 5 or 6 exhibits. So Sarah switches gears, and this is exactly what she says. For the parenting plan, I would like to please put into evidence my number 2 and 3. Then she says, I'm sorry, the parenting plan, the original one. And then she's fumbling around with papers. In my mind, there's like papers flying everywhere around her head, and her helmet is just like tilted to the side. She is frazzled. So she says, the parenting plan, the original one, she'd like to submit the certificate of parenting where both her and the petitioner signed. The certificate of completion signed by both the petitioner and I, yes, I would like to submit that as evidence. Brian, you do remember that you are under oath, right? What she said to Brian as she was cross-examining him.
Next question, ma'am.
I don't know what I'm doing. So Sarah asks Judge Jackson if she can explain some of her exhibits and evidence that she submitted. And Judge Jackson replied, I don't know if there's any explanation needed, but go ahead. So Sarah goes on to say, And there's a long silence. The excellent mother that Sarah is, she goes on to give a heartfelt speech after that long pause, and it goes. From my pretrial statement, my incarceration has nothing to do with me being a mother to my son. It has nothing to do with me being a human and wanting to be a part of his life. And with the active parenting plan, my former husband has excluded me from his life in every way. It has nothing to do with her committing murder. He has alienated me, and that isn't part of the active parenting plan. So since 2020, the day of my incarceration, without any modifications to the parenting plan, he has actively alienated me from my child's life. Instead of encourage the relationship, he discourages the relationship. The certificate of completion is to show the different topics that were discussed in the court-ordered class and to show that he has the understanding. The understanding that he was supposed to act appropriate in front of the minor child in regards to the other parent. Oh, she has a lot of nerve, right? And I shouldn't have to show and prove my worthiness just to be a part of my son's life. I've done everything I possibly can to be a part of my son's life, and the petitioner just says he doesn't care. Sarah is presenting as if this is the way she was on the outside before being incarcerated. It's easy to sit in a room and be taken care of by the state and third-party contributors and not have to pay for anything or even do anything as far as a child and just wait for calls and visits. You know, it's her thinking is really, really childish, maybe. He's not done anything in regards to facilitating me being a part of my son's life. And now it's gone from me talking to my son every day to being dwindled down to one 30-minute phone call per week. I believe that's more detrimental to my son instead of helping him when I have had my parental rights since the day he was born. And I don't believe that my rights should be terminated. They should be preserved. And for him to take that away from me, it's out of bitterness and spite. And people forget that I have a pending appeal to prove my innocence, which is what I've been doing since day one. The reason I was incarcerated in Orange County for 5 years or over 5 years is because I was fighting for my case. I know that the petitioner understands why the 30-50% time sharing it was because of the dangers. I was trying to protect my son. I'm not a bad parent because I was trying to make sure he was safe and in a safe place. The time sharing, of course, it makes no sense to have, we're not talking about relocation anymore. Sarah seems to have just forgotten what she was saying mid-sentence, and she picks back up. I do not think it's fair for me to have one 30-minute call per week with my son when I'm trying to do everything in every which way possible to be a part of his life as much as I can. I'm doing any and everything I possibly can to make sure that he remembers and knows that he has a mother in his life that loves him, regardless of the petitioner and his counsel doing everything they can to stop that. I've tried to communicate with the petitioner about my son. I've only been exploited. There is no communication with the petitioner. I don't know what else it is I can possibly do. And another thing, the petitioner, a lot of this could have been already handled if the petitioner would have just answered his phone. Nonetheless, he could have just answered his tablet messages. It's not fair that just because of the situation that I'm in, that the way I'm being treated. So far, the delusion is real. Sarah has absolutely no self-awareness, just like when she was in the interrogation room saying, "Why is this happening?" She doesn't understand that Brian has to foot the bill she wants Brian to foot the bill for everything. Just to have a conversation with her is pretty pricey. And everyone isn't Lana. Everyone isn't willing to, or her fans, everyone isn't willing to just foot the bill for her. And a limitless amount of text and calls and the multitudinous amounts of technical abilities to visit her and send cards and emojis. And as far as her delicious delights and her snacks and not being able to digest the prison meals, I wonder if she's gotten acclimated to her new prison life by now, because I don't think Judge Jackson is going to want to provide her limitless snacks. However, I do believe her and Brian will break even. I believe he will owe her and she will owe him, and it will probably break, I'm hoping that it'll break even and Brian won't have to come out any more financially than he already has. It's almost a shame how much he's helped her and she doesn't see it, or she chooses not to acknowledge his help and just demands more. It's almost like he was her husband, right? She was sure to correct his attorney and say, "That's my ex-husband, my former husband." So she doesn't want to be connected to him, but she wants to be connected to his finances. What do you think so far? This is episode 2. We're going to transcribe some more of Sarah and her escapade in family court yesterday. Thanks for tuning in. If you made it this far, you know I appreciate you, and I'll see you on the next episode. Bye.